For 7 straight months, my granddaughter and I shared a single room at the Sunrise Transitional Housing Center on the east side of Columbus, Ohio. One twin bed, one cot, one window that faced a brick wall. My son-in-law's family had already moved into the farmhouse my late daughter left behind. The one I spent 3 summers helping build with my own hands, and they told me to be grateful they hadn't called the police. Then, on a Tuesday morning in February, a woman in a gray coat knocked on the door of room 14 and said she had been looking for me since November. She wasn't a caseworker. She was holding a manila folder thick enough to use as a doorstop. 3 weeks after that, my son-in-law's mother stood in a federal courtroom and couldn't remember her own signature. My name is Arthur Cavanaugh. I am 68 years old. I spent 31 years as a licensed electrician in Central Ohio, and I know the difference between a wire that's been cut cleanly and one that's been frayed on purpose. This is the story of how I figured out which one we were dealing with. My daughter Claire died on a Saturday in March. Ovarian cancer, stage 4, diagnosed 14 months before the end. She was 41 years old. She had the kind of laugh that made strangers in restaurants look over and smile without knowing why. Her daughter, my granddaughter Lily, was 9 years old when her mother died. Lily has a condition called nonverbal learning disability. Her IQ is fine, her reading is advanced, but social cues are invisible to her. Large groups make her shut down, and changes in routine can send her into a spiral that takes days to climb out of. She needs consistency. She needs patience. She needs someone who has known her since she came home from the hospital. Claire's husband, my son-in-law, had checked out of the marriage emotionally about 2 years before she died. He wasn't cruel exactly. He was just absent. He worked in Indianapolis, came home on weekends sometimes, and when Claire got sick, the weekends got less frequent. I was the one taking Claire to chemo. I was the one picking Lily up from school. I was the one sleeping on their couch 3 nights a week, so Claire didn't have to be alone at 2 a.m. when the nausea hit. After Claire died, I assumed I would stay involved. I assumed it because nothing had ever suggested otherwise. I had a good relationship with my son-in-law. His name isn't worth saying. I'll just call him my son-in-law because that's the only thing he ever truly was to me, and even that was by extension. His mother is a different story. I will call her what she is, my son-in-law's mother. I had never trusted her the way you distrust someone you've had a fight with. I had distrusted her the quiet way. The way you notice that her room gets slightly colder when a certain person walks into it, and you file it away and don't say anything because your daughter loves her husband and you are trying to be generous. 2 weeks after the funeral, my son-in-law's mother called a family meeting. She used those exact words. Family meeting. She sat at the head of Claire's dining room table. The table Claire had picked out herself at an estate sale in Granville and refinished over one long October weekend. And she informed me that going forward, she would be taking a primary role in Lily's upbringing. I said that was fine, that I expected we'd all be involved. She said that was not what she meant. She slid an envelope across the table. My son-in-law sat beside her and looked at the window. The envelope contained a single sheet of paper. It was a voluntarily relinquishment form, a document used in Ohio family law when a non-custodial relative agrees to have no further contact with a minor. She had filled in my name. She had filled in Lily's name. There was a line at the bottom for my signature. I set it down. I told her very carefully that I was Lily's grandfather and that Lily had been through enough and that nothing short of a court order would put distance between me and that little girl. My son-in-law's mother smiled the way a woman smiles when she already knows the end of the story. She said that could be arranged. I didn't understand what she meant for another 4 months. What I did understand, almost immediately, was that the access dried up. My son-in-law stopped returning calls. Lily's school was notified, I found out later, that I was not on the approved pickup list anymore. When I drove to the house one afternoon in April to drop off a birthday gift for Lily, my son-in-law answered the door and told me Lily was resting, and that he would give her the present. I could see Lily at the top of the stairs. She was not resting. She was watching me from between the balusters with an expression that I can only describe as trying to figure out if she was allowed to wave. I waved first. She waved back and then disappeared. I tried the legal aid office. I was told that as a grandparent in Ohio, my visitation rights were limited, and that without a prior court order, I had limited standing unless I could demonstrate harm. I tried a private attorney. The retainer was $4,000. I had my pension. my social security, and the equity in my house, which was a modest ranch home in Westerville that I had paid off 6 years ago. 3 months after the funeral, I got a letter from a law firm in Columbus. It informed me that my son-in-law was selling the farmhouse and the 2 acres attached to it, that the proceeds would go into a family trust managed by his mother as trustee, and that as a courtesy I was being notified because my late daughter's name was on the original deed. As a courtesy, I called the number on the letter. No one answered. I drove to the address listed. It was a commercial mailbox service in a strip mall. I kept driving. I went home. I sat in my kitchen and I looked at the coffee maker Claire had bought me for Christmas 3 years ago. It was an expensive one. She had wrapped it in paper she'd made Lily decorate with stamps. There was a card tucked underneath it that I kept in the drawer of my nightstand. I was 67 years old. I had done everything right. I had worked, saved, paid my taxes, raised my daughter, been present, and now I was drinking coffee alone in a house that was too quiet, and my granddaughter was 6 miles away looking at stairs, wondering if she was allowed to wave at me. The next month, my son-in-law filed a motion with Franklin County Family Court to formalize sole custody and name his mother as Lily's secondary legal guardian. The filing listed me as having no relationship of significance to the child. It described me as a peripheral contact. The same man who watched me hold Lily in the hospital the night she was born described me in a court document as a peripheral contact. My attorney, I had scraped together the retainer by that point, told me these filings were designed to establish a paper trail, to create a record that existed before I could create my own. I spent October and November preparing a response. I gathered testimony from Lily's former teachers. I printed email chains. I pulled cell phone records of every call I had made to that household in the months after Claire died. 63 calls. 11 responses. What I did not have was money. The Halstead, my son-in-law's family, had a Columbus attorney on retainer. I had a man who worked out of a 2-room office in Dublin and was doing his best. I kept telling myself it would be enough. I kept telling myself that facts would matter. By December, I had spent through the savings I had kept liquid. By January, I had taken a small loan against my house. By February, I was behind on the loan payment and my attorney sent me a letter saying he could not continue without additional funds. I hadn't told anyone how bad it was. I had a neighbor who checked in, an old friend from the union who called on Sundays. But I hadn't told them about the loan or the letter or the fact that I had been eating soup from a can every other night to stretch my grocery budget. The week I got my attorney's letter, I also got a notice from my mortgage servicer. I did the math that night. The kind of math you do when every column is negative. I had maybe 60 days before the bank could begin proceedings. I had no path to additional funds that didn't require a miracle or a sale, and selling the house would take time I wasn't sure I had. I called my attorney one more time and told him I understood. He said he was sorry. He sounded like he meant it. I sat in my car in the driveway that night for a long time. The heat was running. I remember thinking that if I sat there long enough, I would have to go inside eventually, and inside there was nothing I could fix, and out here at least I was just sitting in the dark without having failed yet. That was February 4th. By February 11th, I had surrendered my house to avoid foreclosure and moved into the Sunrise Transitional Housing Center with one duffel bag and Lily's birthday card in my jacket pocket. I want to be honest about something. I did not move Lily with me. She was with her father legally and I had no standing to take her. But I had been allowed 2 supervised visits in January as part of the preliminary court proceedings, and both times Lily had held my hand for the entire hour and asked me repeatedly when she could come stay at Pop's house. I told her soon. I believed it when I said it. I didn't know yet that soon was going to take the shape it took. The Sunrise Center was not a bad place. The staff were professional. The other residents mostly kept to themselves. My room was small and clean. Room 14. I learned quickly that the building was managed by a nonprofit, and that the nonprofit received most of its funding from a private foundation. I learned this because the foundation's name was on a plaque in the lobby, and I had time to read every plaque in that building. I had a lot of time. I had been there 9 days when the knock came. It was 9:20 in the morning. I know, because I had just finished making notes from a self-help legal guide I'd found in the common room, and I had been watching the clock the way you do when you're counting down to a visit with your grandchild, and the visit was at 2:00. Knock, knock. I opened the door. The woman standing in the hallway was about 40, wearing a charcoal coat, professional, carrying a leather briefcase that looked like it had been through a few hundred hours of real work. She was not a caseworker. Caseworkers wore lanyards and carried clipboards. This woman was looking at me the way people look at a problem they have been hired to solve. "Mr. Kavanaugh," she said. "Arthur Kavanaugh?" I said yes. She said her name was Irene Walsh. She was an estate attorney, was Irene Walsh. She was an estate attorney with an office on High Street. She said she'd been trying to locate me since November, and that the court system's address update lag had made it difficult. She said she had a matter of some urgency relating to the estate of my late daughter. I told her I wasn't aware my daughter had an estate. Her husband had filed documents showing there was nothing left after debt. Irene Walsh nodded slowly. She said that was precisely why she was here. She sat in the one chair in my room. I sat on the cot. She opened the briefcase and took out a folder. And inside the folder was a document I had never seen before. A deed, notarized, dated 6 years earlier, showing a property registered in Claire's maiden name. My daughter had bought a piece of land, 22 acres in Licking County, 40 minutes east of Columbus. She had bought it 6 years ago with money from a small inheritance she'd received from her maternal grandmother, my mother-in-law, who had died quietly in 2018 and left Claire a sum neither of us had talked about much at the time. Claire had always been private about money in the way that people who grew up watching their parents argue about it tend to be. The land had a barn on it, a pond, and a gravel road that ran from the county route to a small clearing where she had planned, apparently, to eventually build. Irene Walsh showed me blueprints. They were folded and soft from being opened many times. There were pencil marks in the margins. I recognized my daughter's handwriting. "She was building me a house," I said. I didn't mean to say it out loud. Irene Walsh said yes, she believed that was the intent. I sat with that for a moment. Then I asked why no one had told me about this property. Irene Walsh said because the executor of Claire's estate had filed documentation with the probate court in October stating the property did not exist. The executor of Claire's estate was my son-in-law's mother. She had filed a sworn affidavit with the court claiming a complete inventory of Claire's assets. She had listed every savings account, every personal item of value, every vehicle. She had not listed the 22 acres in Licking County. She had not listed the $9,400 in a separate account Claire had set up through a credit union to service the property taxes and maintenance. She had, however, located a buyer. Irene Walsh showed me a purchase agreement. A real estate holding company out of Columbus had made an offer in November. The offer had been accepted. Closing was scheduled for March 15th, which was 4 weeks away. I asked Irene Walsh who her client was, who had sent her here. She said my daughter had sent her. She said Claire had made an appointment with Irene's office 11 months before she died, while she was still mobile, while she still had time to think clearly. She had established a secondary will, not the primary estate document her husband's family had access to, but a separate instrument called a testamentary trust signed before 2 witnesses and a notary that named Lily as the sole beneficiary of the Licking County property. The trustee appointed to manage it until Lily turned 21 was not her husband, not his mother. It was me. Claire had made me trustee of her daughter's future and then died before she could tell me it existed. And the woman who had found a buyer for that land had filed sworn court documents pretending it didn't exist. I went very still. Then I asked Irene Walsh what we needed to do. She said she had already filed an emergency injunction to hold the March 15th closing. She said the filing included a copy of the testamentary trust, the original deed, and the credit union account records. She said my son-in-law's mother had been notified by the court and that as of this morning, she was aware that her affidavit was now the subject of a probate fraud referral to the Franklin County Prosecutor's Office. She handed me a second document. It was a motion for emergency custody modification filed on my behalf, citing the discovery of the trust instrument as material evidence that the current guardian had misrepresented Claire's intent regarding Lily's care. Irene Walsh said, "The hearing is in 10 days. I looked at the deed. My daughter's signature, 6 years old. Notarized." The paper was slightly waxy, the way legal documents sometimes are. I ran my thumb along the edge of it. Claire had sat in an attorney's office and planned for the possibility that things would go wrong. She had done it quietly, like she did most things, without telling me because she didn't want to worry me, and she had set it all in motion from a distance. I am going to tell you something honestly. I am not a man who cries easily. I spent 31 years on job sites where crying was approximately the least useful thing a person could do. But sitting in room 14 with that deed in my hands, I did not fully keep it together. Irene Walsh pretended not to notice. She is a very professional woman. The 10 days between Irene's visit and the hearing were not peaceful. My son-in-law's mother did not accept what was happening gracefully. Through her attorney, the Columbus firm with the commercial mailbox front, she filed a motion claiming the testamentary trust had been signed under duress, that Claire had not been of sound mind in the months before her diagnosis progressed. She submitted a letter from a physician. The physician turned out to be a family friend who had seen Claire exactly twice in the relevant period. Her attorney also contacted the Sunrise Center's administration to flag, as he put it, concerns about my living situation as relevant to the custody matter. The center's director, to his enormous credit, called me directly, told me what had happened, and said that in his 20 years of running that facility he had never had a more obvious attempt to weaponize poverty against a parent, and that he was happy to submit a letter to the court describing my conduct, character, and circumstances since my arrival. 2 days before the hearing, something happened that I had not planned for. My son-in-law came to the center, alone. Without his mother, he sat in the common room and he looked like a man who hadn't slept in a while. He didn't look like someone who had won anything. He looked like someone who was living inside a decision someone else had made for him and was only now starting to feel the walls. He told me his mother had been handling things. He told me he hadn't read every document before he signed it. He told me the sale of the farmhouse had gone forward faster than he had expected, and the money had gone into an account he didn't fully control. I listened to all of this. Then I told him that his daughter had stood at the top of a staircase and watched me leave without knowing if she was allowed to wave goodbye. He didn't say anything for a long time after that. He showed up to the hearing with a separate attorney from his mother's. He did not sit at the same table. The courtroom was a standard Franklin County family courtroom, wood paneling, fluorescent lights. A judge who had clearly seen everything and was not easily impressed. My son-in-law's mother sat at the plaintiff's table in a navy blazer, composed and prepared, flanked by her attorney. Irene Walsh had told me to let her do the talking. I was good at that. My son-in-law's mother's attorney opened with the usual architecture. He described me as an older man living in transitional housing without stable income, with no legal claim to the child, motivated by grief to disrupt a stable family arrangement. He submitted the original probate filings. He submitted the physician's letter. He described the testamentary trust as a document of questionable provenance created during a period of the decedent's cognitive decline. He was good. I will give him that. He built the case cleanly, brick by brick, and when he was done it looked solid. Then Irene Walsh stood up. She submitted the testamentary trust with its notarization and 2 independent witness signatures, both of whom had provided affidavits confirming that Claire had been alert, specific, and entirely clear-headed on the day of signing. She submitted the credit union record showing regular, organized deposits going back 6 years. She submitted the blueprints with Claire's handwritten margin notes. Then she submitted the purchase agreement for the Licking County property. And then she submitted the sworn estate inventory that my son-in-law's mother had filed with the probate court in October, in which she had attested under penalty of perjury that there were no additional real property assets. The judge looked at both documents for a long moment. He looked at my son-in-law's mother over the top of his reading glasses. He said, "The property at the Licking County parcel number is listed in this purchase agreement with your signature as authorized seller. It is not listed in your sworn estate inventory filed 6 weeks prior. Can you explain the discrepancy?" My son-in-law's mother said it had been an oversight. The judge said a 22-acre parcel with active tax records and a purchase agreement you personally signed is an oversight in a sworn legal document. Her attorney started to stand. The judge held up one hand. Then Irene Walsh played the recording. I had not known about the recording until that morning. Irene had told me in the car on the way over that her investigator had obtained a recording. Legally obtained, she was careful to say, through a mutual acquaintance who had been present for a conversation in which my son-in-law's mother had discussed the Licking County property with her real estate contact, specifically describing it as a loose end they needed to close before the old man found a lawyer. The old man. The room was quiet enough that I could hear the fluorescent lights. My son-in-law, at the supper table, had his hands folded in front of him and was looking at the floor. The judge closed the folder on his bench. He took a breath. He said that he had rarely seen a more direct example of a fiduciary misrepresenting an estate for personal gain, and that the matter was being referred to the Franklin County Prosecutor's Office for review. He said the emergency injunction on the property sale was made permanent pending the probate court's full review. He said that based on the testamentary trust and the totality of evidence regarding the management of the estate, he was granting emergency modification of the custody arrangement and appointing me as Lily's primary residential guardian, pending a full hearing. He turned to my son-in-law's mother and said, "This court does not look favorably on individuals who file sworn statements they know to be false. You are dismissed from your role as estate executor, effective immediately. The court will appoint an independent administrator." Her attorney was already gathering papers. She sat very still. She looked smaller than she had an hour ago. She didn't look at me. I was glad. I did not want to see her face and feel anything other than what I needed to feel in that moment, which was nothing, so I could focus on what came next. What came next was the door at the back of the courtroom opening. Lily's court-appointed guardian ad litem had brought her. I had not known that was going to happen either. Irene Walsh understood things about timing that I was still learning. Lily walked down the aisle between the gallery benches. She was wearing her green coat, the one with the corduroy collar that she refused to stop wearing even though she'd had it since second grade. She looked at the judge, at the bailiff, at the fluorescent lights with the expression she gets when she is processing a lot of information at once. Then she found me. She walked straight across the front of the courtroom and wrapped both arms around my waist without saying a word. I put my hand on the back of her head. I didn't say anything either. There wasn't anything to say that the two of us standing there didn't already cover. "Pop," she said finally, into my jacket. "Yeah," I said. "Is this done now?" "Yeah," I said. "This is done." The fraud referral moved quickly. The Franklin County Prosecutor's Office had been keeping a file on a related matter involving the real estate holding company for other reasons, and the addition of the Licking County transaction became the piece that connected several things they had already been looking at. My son-in-law's mother was indicted on 2 counts of probate fraud and 1 count of filing a false instrument. Her attorney negotiated the statement down, but the investigation into the holding company continued, and her cooperation was required. She did not attend Claire's grave on the 1st anniversary of my daughter's death. I know because Lily and I were there, and I would have noticed. My son-in-law, to his credit, did not fight the custody modification at the full hearing. He and I have an arrangement now. He sees Lily on alternating weekends and 1 dinner per week, and he calls when he says he will, which is improvement. I think he is trying. I think he is a man who spent several years making the choice to be less present than he should have been, and is now living with what that cost him. That is not my punishment to give or take away. That is just what is true. Irene Walsh connected me with a Columbus nonprofit that provides legal and advocacy support for grandparent caregivers in Ohio. I've gone to 3 of their meetings. I'm not much of a joiner, but I showed up. There are a lot of people in those rooms who are doing what I was doing, counting change and writing down every phone call that went unanswered. Some of them are further back in the story than I was. I tell them what I know, which isn't much, except that documentation matters and that the people who are moving fast and confidently against you are almost always moving fast because they are trying to get somewhere before you can see what they're carrying. The Licking County property is in Lily's trust. I am the trustee. We drove out there in April, the first warm weekend, and walked the 22 acres. Lily is not a particularly outdoorsy kid. She prefers her books and her routines, but she walked the whole property with me, stepping carefully around the mud near the pond, stopping to look at a hawk that was sitting in the oak tree at the edge of the clearing. She found Claire's penciled initials carved into the frame of the barn door. She touched them for a long time without saying anything. I gave her the space to do that. We are not building the house yet. There are still legal proceedings ongoing related to the estate, and I am not a man who builds a foundation until the ground is settled. But Lily and I have talked about what she wants. She wants a room with 2 windows. She wants a room with 2 windows. She wants a reading nook. She wants to be able to see the pond from the kitchen. I want to give her those things. I plan to. I am 68 years old. I have a bad knee from 31 years of crawling through tight spaces. My coffee maker still sits on the counter in the rental house I have now in Westerville, 3 miles from Lily's school. The birthday card from my nightstand is in the kitchen drawer now, closer to hand. There are things I wish I had done differently. I wish I had learned earlier that patience is not the same as passivity. I wish I had understood sooner that the people moving documents around and filing motions and changing pickup lists were counting on me to stay confused and tired and slow. They were not wrong about the tired part, but they were wrong about the slow part. And they were wrong to count on me staying quiet in a transitional housing room while they sold 22 acres of my daughter's intentions to a holding company. My daughter believed that what she had prepared would reach me eventually. She trusted that the system she had carefully put in motion would find its way to me. She was right, but it was close. The closing was 4 weeks out when Irene Walsh knocked on my door. 4 weeks. If Claire had not found an attorney she trusted, if that attorney had not been methodical enough to track a pension address to a transitional housing center, if the injunction had been filed a week later, there would have been nothing left to find. I think about that 4-week window sometimes. I think about what I was doing in those 4 weeks, eating soup from a can, counting the days to supervised visits, writing down 63 calls in a legal pad. I was doing the right things without knowing the right things were already being done for me by a woman who had understood something about her life that she never quite got around to saying out loud. Take care of my girl, Pop. She didn't say it at the end. She didn't have to. She'd been saying it for 9 years every time she showed up at my door with Lily on her hip or called me to come sit with them because she was tired and she trusted me to stay. I heard her. I'm still hearing her. If this story brought up something real for you, leave a comment. I read every one of them. Tell me where you're watching from. Tell me about the family member you're fighting for right now. And if you know someone who is in the middle of what I was, in the middle of, tell them to document everything. Write down the dates. Keep the emails. Do not assume that things will sort themselves out, because things do not sort themselves out on their own. They sort themselves out because someone decides to stay in the fight long enough to see what's actually there. That person might as well be you. I've spent a lot of time since the hearing thinking about what my son-in-law's mother actually believed. I don't think she believed she was doing something wrong exactly. I think she believed she was doing something efficient. She looked at the situation. A grieving old electrician with no attorney, a piece of land no one had publicized, a closing date 4 weeks out, and she calculated that efficiency would win. That is the part that stays with me. Not the greed, which is ordinary enough, but the certainty, the absolute confidence that no one was going to look closely enough or move fast enough to stop her. That confidence was the thing that undid her. People who operate the way she operated, quietly, behind documents, through systems they assume others don't understand. They tend to believe that speed is the same as safety. Get the paperwork done before anyone notices. Get the sale closed before anyone asks. File the affidavit before anyone compares it to anything. And it almost worked. 4 weeks. That is how close it came. What she did not account for was Claire. My daughter had done something I would not have thought to do. Probably because I'm not the kind of person who imagines the worst-case version of the future and then quietly prepares for it. Claire was. She always had been. She was the kind of person who renewed her car registration a month early and kept a go-bag by the back door during tornado season and, apparently, sat down with an estate attorney while she could still drive herself to the appointment and built a legal structure designed to outlast her and reach me even if everything else fell apart first. That is not luck. That is a particular kind of intelligence. The kind that looks at the present clearly enough to see exactly what the future might require. I think about that a lot now. I spent those 7 months at the Sunrise Center feeling like the world was moving faster than I could track it. Documents filed, motions entered, lists updated, locks changed. I was always 1 step behind. What I didn't understand was that Claire had already been 2 steps ahead, years earlier, on a day when I didn't even know there was a game being played. The lesson I carry from this is not about legal strategy or documentation, though those things matter enormously, and I would tell anyone in a similar position to write down everything and save every email and never assume a verbal agreement means anything in a room you can't prove you were in. The deeper thing I carry is about the relationship between how you live and what survives you. My son-in-law's mother made decisions based on what she could take. Claire made decisions based on what she could leave. And when those 2 approaches finally met each other in a Franklin County courtroom, one of them had a signed deed and 2 witness affidavits and a credit union paper, trail going back 6 years. and the other one had a purchase agreement with her own signature on a property she had claimed didn't exist. That is not coincidence. That is the long result of two different ways of moving through the world finally catching up with each other. Lily touched her mother's initials on that barn door in April and didn't say anything for a long time. I didn't either. There are moments that don't need language. What Claire carved into that wood wasn't just her initials. It was evidence that she had stood in that clearing and imagined a future worth preparing for. She prepared for it even when she was sick, even when she was tired, even when she had every reason to focus only on the present moment. I am trying to do the same thing now, not because I am brave, but because she showed me what it looks like when someone decides that the people they love are worth the extra effort of thinking ahead. That is the inheritance she actually left me. Not the land, though I am grateful for the land, but the example, the quiet, persistent, undramatic example of someone who loved well enough to plan carefully. I intend to honor it.